Today, we're launching the SEDROP series, which is a project that is dealing with election dispute resolution, and it's implemented by SAIPAR in collaboration with a few other CSOs, including Chapter 1 Foundation. Today, we're joined by Henry from Chapter 1 Foundation, which deals with strategic public litigation, or rather, public interest litigation, and he'll be discussing what Chapter 1 Foundation does generally, as well as its role in the SEDROPS project. Welcome, Henry.
Thank you, Maria. Thank you. I'm
Thank
happy
you.
to be here, by the way.
Yeah, thank you for being here, for joining us. To start, what is Chapter 1 Foundation, in case there are a few people who do not know what your organization is?
Yes, well, Chapter 1 Foundation is an organization or an NGO that deals with the promotion and protection of, number one, human rights, constitutionalism, rule of law, and good governance. So Chapter 1 Foundation does all those things using or through civic education, strategic public interest litigation, advocacy, among other things. So Chapter 1 Foundation derives its name from Chapter 1 of the Laws of Zambia. Chapter 1 of the Laws of Zambia is the Constitution, which is the supreme law of the land. So at the center of what Chapter 1 does is to ensure that people everywhere in this country, regardless of their social status, gender, or sex, participate in the governance of this country. So then how do people now participate in the governance of this country? So at the core of what Chapter 1 does is to ensure that people have knowledge or are informed. So that's why Chapter 1 Foundation does civic education, including public interest litigation, which we'll be talking about. So mainly that is the role of Chapter 1 Foundation, to promote and protect human rights, and at the center ensure that everyone participates in the governance of this country.
Okay. And tell us about your work as Henry at Chapter 1 Foundation.
Well, that's a straightforward question, but difficult to answer. My work at Chapter 1 Foundation, well, at Chapter 1 Foundation, I am an advocate. So I support litigation, yeah, as a way to put it. I also do programming, even though programming is not my passion, but the work of an advocate in an organization like Chapter 1 includes being able to do programming. So programming involves, for example, like I talked about civic education, it involves now preparing what should inform the teaching or the civic education. So you find that you are sometimes doing procurement, you are traveling between towns to talk to other CSOs, sometimes citizens. So mainly I support litigation at Chapter 1.
You have mentioned litigation, you've mentioned strategic litigation or strategic public interest litigation. What is that?
Just like the term itself reads, strategic litigation or strategic public interest litigation. So strategic public interest litigation is litigation that aims at influencing change for the greater good, not just for an individual, but for the public. So it's strategic in the sense that mainly when people go to court, you find that as an individual, let's take, for example, since we're talking about elections, let's say a candidate, at the point of finding nominations, ACZ tells them, no, you do not qualify because of one thing or the other. then that individual will try to protect their individual interest. Then perhaps they'll go to court, to, let's say, the High Court, to ask a specific question, or to ask the High Court to review the decision, not to allow that person to proceed with their nominations. So that is an individual's interest, and the benefit will go to that individual. Of course, we can talk about, that person, for example, is contesting to represent a constituency, but the direct benefit would go to that individual. And the whole essence of going to court is that that individual wants sort of to win, to get some form of justice. For strategic public interest litigation, on the other hand, in some cases, the goal is not about winning a particular case. Okay, the goal is about sometimes uh, ensuring that the public buys in what the case is all about. I'll give an example of Bill 10 in 2019. Chapter 1 Foundation and the Law Association of Zambia went to court challenging Bill 10 then. Okay, even though the court ruled against Chapter 1 and ECZ, just before the decision was made, or the time leading up to the decision by the court, we saw that a number of stakeholders rallied behind Chapter 1 Foundation and the Law Association of Zambia. And it led to so many people understanding what actually that Bill 10 was about. Because people just, Bill 10 this, Bill 10 that. So it led to a point where the public now got interested. What is this that Chapter 1 and the Law Association of Zambia are talking about? So even the court said that the case had no merit. The public rallied. So that's we're talking about strategic public interest litigation. So sometimes it's not about winning, but to get the public buy-in. Then strategic, sometimes for individuals, it's just a case, it's filed. Then you forget about it, or just go with the process. For strategic litigation, there are other things that go with litigation in court. You find that there are issues of advocacy. Sometimes we see where a case is filed, we see other litigants now informing the public. We filed this case in court challenging, I'll give an example of in the past few months, we saw there was talk of an MOU between Zambia and the USA. The case was filed in court by Chapter 1 Foundation and LCK Freedom Foundation. And we'd see posts being made informing the public, Chapter 1 and LCK filed this case. So that's advocacy. Okay. Sometimes you're not just trying to win, but you want the public to be aware, to start talking about that case. So it's not always just about winning, but the public buy in, for example, and to influence. Sometimes if the government has seen that, okay, this case or issue has now turned into public talking about this, what should we do? Okay, let's go to the table, let's withdraw the case. Parties, what do you want? Then like that. It's not always the way individuals, I want to win this case, but there are those that fall. Yeah.
Okay. If you allow me, I'd like us to just take a step back and look at the region, or maybe even the continent, and how strategic public interest litigation is being practiced, in the continent, and what lessons can be learned from, those experiences.
Okay.
Yeah.
So if we look at the continent, there are a number of cases, strategic cases that have influenced even how certain rights are enjoyed, or how systems uh, are benefited from by the public, or how even the government tends to now shift policy. So I'll give an example of so in South Africa, there's a case of the Republic of South Africa versus Grootboom. In that case, we saw the court complaining or saying that the government of South Africa was supposed to ensure that those people were removed or evicted from the unplanned settlement area, that the government was supposed to ensure that they made provision for shelter conducive for such people, okay, thereby reinforcing the social and socio-economic rights. That case has been used by many, even in this country, students, researchers, to try to influence the country of Zambia to sort of put economic and social cultural rights in the constitution. The other case I would refer to, again, in South Africa, the economic freedom fighters versus the Speaker of the National Assembly. There we saw the court again saying that a president should be subject to laws, it should not be above the law, and that parliament should ensure that they take their role of oversight over the executive very seriously. And that case again has been used by people trying to influence change in this country. The other cases I would refer to again on the issue of elections in Kenya, where the Supreme Court in Kenya sort of set aside the election results and ordered another election. There, the issue was there, the court saying that when it comes to elections, it's not just about the results, but everything that happens leading to the announcement and people voting should be taken into account in looking at how is the result. So when you look at such cases, they tend to show that indeed strategic litigation can be a very good tool for influencing good and positive change. Um, the lessons that we can learn in terms of those examples that I've given is how do we approach strategic litigation? Okay, that is in terms of the planning. Like I said, it's not sometimes it's not just about winning a case. Okay, so the lessons we can get as a country should is on all layers. Okay, from the executive, the legislature, and the judiciary, because litigation itself, when a decision is made by a court, it would not transform into change if nothing is done about it. Because if you are talking about a litigation, the court or the judiciary, or the judiciary passes a decision, if there is no political will, for example, on the part of the executive to heed to a judgment, if the directives given, so to speak, on the executive, if there's no political will, then it means that that judgment, even though it's a good judgment, progressive judgment, will not lead to anything. Again, if the public is not interested or concerned in ensuring that what the court says is implemented, then it won't do anything. So the lessons that we can learn is that everyone, all the parties involved, the legislature, judiciary, and then also the public, including CSOs, should ensure that they perform their roles. CSOs sensitizing the public. From CSOs, we have people who have studied law, who are able to interpret or explain laws. So they could take that role, base a judgment. For example, let's say, give an example of the right to vote for people in custody or incarcerated. There's a decision in this country. It would take before there is even an amendment, for example, after a decision, the people in lawful custody or people incarcerated would benefit from, let's say, CSOs or other stakeholders getting on board and explaining this is a decision that we have. So the government or the legislature, your role is this. For us as CSOs, we will help in terms of speaking to people, let's say, areas where it's difficult for many other people to reach. So those are some of the lessons that we can learn, all parties involved.
Okay. And in relation to election, disputes, right? Do we see the courts having, the capacity or the potential to be catalysts for this positive change that you spoke about?
Yes, we do see the courts to be a catalyst. So when we have laws passed by the legislature, and in most cases you find that the constitution is not as specific, so to say, sometimes couched in broad terms. Okay, and courts are there to clarify laws sometimes or give meaning to provisions. An example I can give is the issue of what happens where a candidate, let's say an MP, is elected, then there's a petition. Okay, there is a case of the Law Association of Zambia, this is the Attorney General. So the Law Association of Zambia went to court because in the constitution there are provisions that say that when you have been elected as an MP, then your seat is petitioned. Okay, so the petition goes to the High Court. Okay, so if the High Court says that, okay, yes, you were not validly elected, then the law says that that person will continue to hold their seat during the hearing of that petition. But there's no issue of the appeal, because if let's say the High Court says yes, you are not validly elected, then you appeal to the Constitutional Court. The Constitution is silent as to what happens when you appeal. Should you continue holding the seat or should you surrender? So now, in that case, the Law Association of Zambia went to the Constitutional Court. Can you explain what these provisions mean? And the Constitutional Court said that yes, here there is a lacuna, as they say, a gap. Yes, there's a gap here. The Constitution does not explain what happens in that case. So, for example, in that case, let's say the High Court says yes, you are not validly elected, and then you, as an MP, was announced or declared the winner, you are put aside. Another person comes in. What happens now, where the Constitutional Court now reverses the decision of the High Court? So, in such cases, the courts could act as a catalyst, because once that decision is passed, it becomes law. Okay, and we do not have to wait for example, for the Constitution to be amended. Okay, so in that sense, the courts would act as a catalyst. But then again, going further, if the court passes a decision like that, yeah, if the ECZ, the Electoral Commission of Zambia, or even the legislature, they are not willing to implement what the court says, then it means even that decision by the Constitutional Court would not mean anything. And this is what we're talking about when I was saying that for us to benefit, okay, and in terms of the nations, it means that all the parties have to work together. The courts, the executive, and the judiciary. I'll give another example. I know it's not related to elections. I think 2018, the Supreme Court passed a decision in terms of prisoners, rights of prisoners. Yeah, the Melvin Vene and another. This is the Attorney General. So in this country, we do not have the right to food, so to say, or the right to health. Okay, but we have the right to life. Yeah. So these prisoners now who HIV positive and on ARV drugs or treatment, they went to court to say our right to life is being violated because of the kind of food we are getting and not being able to access treatment. Okay. So the courts were able to say, oh, yes, indeed, it makes sense for someone to enjoy fully their right to life. They have to have access to proper food and nutrition and so on and so forth. Okay. So now, if that progressive decision is passed by the courts, okay, and we know that the executive, through correctional services, even legislature or parliament, allocating monies or budgets to prison services, if they neglect after that decision, which says that to even allocate to ensure that there are proper health care or services available, the food or nutrition is okay based on an inmate's condition. If they do not make provision for that, then it would mean that the decision of the court would not do anything. Because the other important thing also is that courts do not go about even just moving on their own. Once a decision is passed, then their job is done. They are not going to start now pushing for implementation. So that it's very important that all the parties concerned, institutions or arms of government, work together. And that decision in South Africa, EFF, this is the speaker, on the issue of separation of powers, it's very important that institutions understand that it's not about fighting each other or showing that the judiciary is higher than the legislature or the executive, but a recognition that these institutions are in their places because of the people. They are put in those places because of the people, and the powers they exercise or their functions they exercise derive from the people. So whatever they do should be for the benefit of the people. Yeah.
Okay. Um, this one, I'm tapping into your knowledge now. Um, when we look at, the in relation to elections specifically, are there any trends that you've observed that speak to gaps in our laws or in our systems where electoral dispute resolution is concerned?
Um, at the moment, previously we had the issue of dealing with electoral disputes after announcement of results in terms of the timelines. Okay, there was the issue of because the constitution says that electoral disputes should be decided timely. Okay, previously we had where the constitution was saying that an election petition should be heard, say, within 14 days or 30 days. Okay, but then with the way the law is, if we remember in 2016, the petition of the current president against the attorney general and the former president, the immediate past president, the issue was on the timelines within which the court should hear a petition. Okay, so now parties ate into the time, that 14 days, just uh, finding one application after another, which led into the court not deciding the main petition because the court said we are constrained. Constitution says within 14 days we have to hear, but it did not say you have to hear and determine. So now that has been clarified, and we see that even this case which is in court now, judicial review over the use of the candle as a symbol for independent political parties, we see that the court now is emphasizing that parties have to ensure that they move quick, okay? Because there's that obligation you have to now hear and determine. So for now, what I think may need to other issues of think nominations, and then also the constitution has introduced proportional representation seats. There, um, the issues that I see may need to disputes within the realm of the allocation, even though the Electoral Process Amendment Act of 2026 has provided sort of like a guideline on how computations will be done. There's no guidance for councillors or council chairpersons, but there's for MPs, those women, youths, and persons with disabilities. I see that those may need to um, disputes because, again, the time between when these laws were enacted and the elections, there hasn't been enough time for people to understand what actually the law says. And then also the other issue that I think may need to dispute has to do with the function or the role of the Electoral Commission of Zambia. When you look at it from their mandates, their appointments, and how transparent they are in terms of their decisions, how impartial they are in terms of their decisions. Because already so far we have heard people saying that the Electoral Commission of Zambia has not been impartial. We saw a few days ago the ECZ published a roadmap or timetable for campaigns for presidential candidates, and we have seen that on that timetable or the roadmap, all the presidential candidates have been given a timetable except for the incumbent, the president. So I see also that may raise an issue because people will be saying that the ECZ is not being impartial. Then bring into question of how the ECZ, the commissioners are appointed and things like that.
Okay. Um, you spoke about the proportional representation, and it just had me thinking about participation and inclusion, and perhaps the role of strategic public interest litigation in increasing or encouraging participation and inclusion. Do you have any thoughts on that topic generally?
Yes, actually. And currently Chapter 1 Foundation is in court. Specifically, it relates to representation of marginalized groupings. But if I can talk about representation of these groupings and the right to vote. So we know that these seats, reserved seats, these are the 20 women, 15 youth, and 5 persons with disabilities for MPs, for example. These will not be voted for by the people directly. It would be the president or the party nominating the people. And questions have been raised over the independence, if you like, or the loyalty of these women, youths, and persons with disabilities because they would not be voted for by the people. So questions have been raised to say these who have their loyalty to the party or the president and not the people. But speaking about this proportional representation and case that I was talking about, Chapter 1 Foundation is in court now over the representation. So when we look at the constitution, it gives the Electoral Commission of Zambia the mandate to oversee elections, okay, or the electoral process. Also, the constitution says that the electoral process shall ensure equitable representation of various groupings, okay, and political parties also. The constitution says that political parties shall ensure that those who are nominated, okay, or political parties should exercise equity in terms of the people that they send or nominate for these various positions. Okay, so now the case for Chapter 1 Foundation in court is that we're basically just asking the court, okay, can you tell the nation what it means, for example, when the Constitution in Article 259 says that in appointment to a public office, you have to ensure that there is equitable representation of various groupings. Okay, so one of the questions would be, what does it mean when we say that those who are nominated for appointment, there should be a consideration for various groupings. Where should it start from? Okay, should it start from political parties when they are nominating persons to contest for elections? Okay, what should be the role of the Electoral Commission of Zambia when they are receiving nominations? Are they mandated or are they subject to Article 259, for example, to ensure that the nominations that they are receiving from political parties are taking into account the issue of representation? So that is the angle that we have approached the Constitutional Court with. So, in terms of the numbers, as we see the amendment now, the view is that this is a very positive step. Okay, but when you look at the numbers 20, 15, and 5, it's are negligible. Okay, the other argument would be that we're talking about nomination to these offices, and then we have these reserved seats. The other argument would be that this now may now entrench issues where women, youths, and persons with disabilities are more sidelined, because political parties may just say, okay, for nominations, let's pick that one who we think is going to win. But for women, youths, and persons with disabilities, for you, they are reserved seats. So there's no need for you to worry about this nomination. But yeah, from that context, that's how I can put it.
Okay. As you are talking about the case related to the right of prisoners to vote, I was thinking about the role of CSOs in strategic public interest litigation. I mean, it's clear the role, chapter one, right? In the case that you cited, the Godfrey Malembeka, it was clear the role of Priska. But then, can you just tell us about like other organizations and how they can advance strategic public interest litigation?
Okay, so like I said, strategic litigation is not just about going to court. Okay, it's accompanied by advocacy, for example. Okay, getting the public's buy-in. So some of the things that other CSOs can do would be, for example, sensitizing the public. Okay, it could be an issue of uh, we have a number of CSOs that have presence in the most rural parts of Zambia, okay, where maybe SAIPAR would not have, or even Chapter 1 Foundation, okay, or the state, the government, or the state is, say, the mighty state, they have resources, but it's not always that the government, although there may be the presence of the government, it's not always that there may be uh, funds, for example, for people to in government to even explain some of these things to people in the most rural parts of Zambia. And we find that a number of CSOs, because of the nature of work that they do, for example, Alliance for Community Action, they engage with communities. Okay, so in a case where there is a judgment, let's say the Godfrey Manembeka case, okay, an organization or CSO like Alliance for Community Action and the others could take the role of explaining to the people. Okay, not just in the context of, let's say, the Constitutional Court says that even people incarcerated should vote, but then in the broader context of what is the right to vote, okay, what does it mean? Okay, let's say they explain the right to vote or voting is one way through which every Zambian participates in the governance of this country. Okay, and what does it mean? Then it goes to say, okay, it means that every person has the right to participate, and not just people on the outside, but even people in custody. Okay, and this is why the right to vote is important, because this is their voice. Okay, this is how they express themselves. Okay, such that the law now recognizes that whether you are in custody, okay, you have the right to vote. Okay, in I was listening to the chief electoral officer Is it Mr. Brown Casaro. A question was posed to him over whether the ECZ or the country intends to make provision for people in the diaspora to vote. Okay, so again, we're talking about the right of Zambians, okay, to vote, how you express yourself, how we express ourselves. Okay, so organization could take that role, okay, based on their audience, the audience that they have. Uh, sometimes Chapter One Foundation engages with fellow CSOs. Okay, when we meet, let's say we are in Southern Province, you'd find that people among the people invited, you have some people from government, sometimes the Human Rights Commission, other CSOs, and the intention there is, like I said, Chapter One Foundation wants to ensure that every person has the ability to participate in the governance. And how do you have the ability? Is that you have to know, you have to have the basics, for example, civic education. So when you talk to these people, the intention is that they'll speak to others in the communities and things like that. So that is one role that CSOs can take. Okay, they can work with governments. Okay, using their social media pages. Like I said, when they go to, if you are in Dumdumwezi, for example, you are in Trauma, or you are on the Copper Belt, CSOs would take that upon themselves to educate or sensitize the public to say, okay, the right to vote is important, is key. That is why even the courts now have said that even prisoners should exercise their right to vote. Then, by extension, what does that mean? Then it means that, also explain, it would mean that, okay, how then will people or those who are vying for office campaign in those prisons? Okay, so what now is the role of who? Let's say prison officials or the officer in charge, or what should the Electoral Commission now make available? So CSOs, I say infographics, talking to people, engaging government, how should we work together now? So CSOs have a huge role. Like I say, CSOs usually act as a bridge, okay, between what government should do or can do or supposed to do in the immediate. And because of the limitations, that's where now CSOs can come in to ensure that we have that benefit explained to the citizens.
Yeah, to supplement government efforts. Okay, now after you have done your job as an advocate and say you've gotten a judgment in favor of your cause, we've seen issues with the judgments not being enforced, right? You mentioned lack of political will as being one of the reasons. Are there other reasons why some of them are just not implemented?
So sometimes, so we talk about political will. The other reason could be how, for example, relief is given by the court. Yeah, it should be something that is capable of implementation. For example, okay? I'll give an example of um, the case I talked about, rights of prisoners in detention. Okay, if the court says that prisoners are entitled to right to proper food and nutrition, okay, is that capable of implementation? Okay, how easy is it for the state to implement or make provision for that? So some of the reasons could be, like I said, how the release couched or phrased, but the most or the major issue is political will and the way it's phrased when, because judiciary passes a judgment. If issues of political will come in, the thing we hear is about funds, okay, funds, and sometimes it's an issue of, I think political will is the major thing because it is broad. Yeah? If we talk about political will, then away from the issue of funds. It now has to do with, does the executive work well with the judiciary? How do they coordinate? How is the separation of power? Okay. Are they willing to obey the decision of the court away from just even availability of funds? The other thing is the public. Okay. What is the public's participation, for example, in the decision of the court? If a decision is given, okay, and this is where now, like I said, chapter one foundation of ensuring that people participate in the governance, they have the basic civic education. If a decision is passed, progressive decision, okay, and the court says, for example, for you to make changes to a constitution, you have to ensure that the public participates, okay. The public should be uh, the originators, okay. If that decision is passed and then the majority of citizens or public do not even understand what that decision is, what it means, it would not motivate the executive to do anything. So the other important thing is the public's involvement, okay? And other partners, we talked about CSOs, they have to be at the center to ensure that the judgment is readily available or explained to the public. And the public is also told that this decision means ABCD for you. Okay. For us to ensure that we get the full benefit from this judgment in terms of what the court says, we have to do ABCD. We have to keep pushing the executive, for example. And that goes to post the judgment. How do you ensure that you are pushing, if it's let's say Ministry of Health is directed to do ABCD to ensure that there are few or no cases of medical negligence on the part of nurses or medical doctors. If there's a decision that is passed and then there's no follow-up, there's pushback, the public talking about it on the media again, media houses publicizing. The thing that we see, and this for me, I think is a very, very serious thing. I don't know if it's because people are too busy or they are not really concerned about the happenings, important happenings, or it's because maybe they do not understand. Many other times when we see that there is a very issue of public importance, okay, you only see or hear people talk about it maybe one day or within a week. Another issue would come in, it would die down. But if we're talking about the issue of how we make changes to a constitution, okay, if that decision is passed, okay, or if there is a decision that says prisoners should vote, okay, if those decisions are passed and then the media quiet, CSOs quiet, government, public quiet, then it means if there's no political will, again, especially if you see that there's no immediate benefit for the people in office or government, then it's highly unlikely that uh, executive or ministry directed through a judgment would move to heed to what the court said. So political will, the media, CSOs, and public involvement sustained, not just 2 weeks or 1 week you talk about it, then you move forward, you start talking about other things. The courts and legislature and judiciary, we even see that, okay, here the nation is serious. If it means um, there being an amendment to a statute, then you'd see that line ministry or the legislature will move in very quick to ensure that there is an amendment. Um, I can talk about the issue of the elections. Okay, within what time should you hear an election petition? What happened in 2016? After that decision, where the court said that no, we are constrained, 14 days has passed. We have no jurisdiction. Immediately after that passed, we saw that there was an amendment, okay, where now the Chief Justice, okay, there was an SI that now clarified. So this means now not just hearing, but also determining within 14 days. And that put that issue to bed because of the public uproar then, because of what had happened. Okay, the public, in terms of just general citizens, CSOs, opposition political parties, even the media. So away from political will, also the other issues that I've mentioned in terms of the other stakeholders' involvement.
Their active involvement. Um, you mentioned the proportional representation as being one of the issues that might be the source of litigation in the 2026 round of elections. Are there any other things that you think will attract interest, um, considering the change to the Constitution and the Electoral Process Act as we near the election?
As we near, what will attract attention, the main thing, what people mainly talked about, for example, in the last elections, the majority of them have been addressed. For example, what happens where a candidate resigns, okay, or where a candidate dies, okay. The main thing now, uh, I think those are the main things, the proportional representation. And like I said, it's difficult in a situation where the majority of citizens are preoccupied with other things. As at now, as you have seen, in terms of campaigning, what is going on, the pre-elections, some of the challenges would be maybe raised against the Electoral Commission of Zambia in terms of how they are performing their role in administering the electoral process. Yeah, some of the issues maybe could be the ECZ not being fair or impartial. I talked about the timetable for campaigns. There's also the issue of the use of a symbol or campaigns for independent candidates. Then there was an issue of pockets of violence. So in southern province, in Rosabuka, and there's another district, I think, in northern province. Okay? So all these center around some of the complaints were that no, the ECZ was not doing its job in terms of penalizing political parties found to be involved. So some of the issues that I see have to do with how the ECZ, the Electoral Commission, is administering the elections, how people campaign, what they use, if and when ECZ will be involved in penalizing the candidates or political parties. The other major things have been addressed when you hear the petition. What happens when a candidate resigns after they've filed in nominations, but before an elections, those have been addressed by the amendment. For this proportional representation, because the law says that these will be apportioned after the announcement of results and declaration uh, of presidential candidates, for example, there are little or no issues that may arise at this stage over how those seats will be apportioned.
At this point, I'll ask you if there's anything that you think is pressing for us to discuss as well, in addition to what we have already discussed as regards elections and election dispute resolution.
Okay. One major thing I think has to do with political party financing. Yeah. From the time the the constitution was amended in 2016, there has been a call for the enactment of the political parties bill to address some of the things like political party financing and the other issues I talked about to do with how candidates or people are nominated for various seats in several constituencies. That law has not been passed. We have heard on a number of occasions, even from the previous government, saying we're working on a bill for political parties, a political parties bill. That law is very important because, you know, many have said, and I think this is true, that it's very important to understand where political parties or those vying for office are getting their funding, because ultimately it would inform the understanding of what government would be after, for if they are elected. If it is a political party, for example, electorates would be able to understand if, for example, we have a party that is being sponsored by a terrorist organization, for example, or they are being sponsored by a foreign government with non-interest, for example, in the country's minerals, that would inform if I am voting. It would be very important for me to make a reasoned decision why I should vote for this candidate, because I would know that if I vote for this candidate and this non-entity that is sponsoring the campaigns or giving money, it would mean that once this party is elected, then that foreign interest will be in charge of kind of running the government. And because of their known interests, let's say in the oil that we have as a country or the copper that we have, it would mean that all these will be channeled through that country, or they would be the primary beneficiaries. Okay. The other component would be, if you do not know how, we are talking about equitable representation. Okay, we do not know the considerations that are made for political parties to nominate candidates for elections. Okay, we have heard many stories about how women, for example, are disadvantaged. Okay, so if we had a law, political parties law, that would spell how. I know these others would argue that these are matters of internal procedures for political parties, but we need a guiding law of principles to say, okay, the political party should disclose, for example, who's financing their campaigns. Okay, there should be guidelines for how they nominate candidates for a particular position, so that if I were to say, okay, I want to understand the kind of candidates, why, for example, this candidate or these candidates are going to this political party, I would be able to know that, okay, it's because they follow this political party's interest in doing ABCD, or it's because they understand that this political parties provides for equal opportunities for women or youths or persons with disabilities. Without such a law, I think we'll still have questions on how are these campaigns being funded. Okay, who is the person or the entity behind this? Okay, who do we risk seeing as the ultimate controller of government if this party is elected? So I think for me that issue of political party financing, or there being or lack of a political parties law, I think it is one issue that needs to be addressed. And the Electoral Commission of Zambia, as the chief or the principal entity that the Constitution gives the authority to manage and run elections should take interest and ensure that there is a law so that we even have predictability. We understand because at the center of this, we are saying that the owners are the people as the citizens. Okay. So if everything is being done genuinely and for the interest of the public, okay, to serve the public, then it should be easy or straightforward or in the best interest of everyone to understand the way it is, for example, in America or in other Western countries. Okay, we have to know where the money is coming from. Okay, like they say, follow the money, and they do not allow, for example, in America, for people outside country to donate or contribute to a party or a person that wants to run for elections. So yeah, that is a major issue that should attract the ECZ's attention.
As we close, I'd like you to just speak on the role of strategic public interest litigation in strengthening or ensuring the strength of our democratic future as a country.
Um, Strategic litigation, that's like it says, strategic litigation is very key in ensuring that the institutions that we have are run for the benefit of the citizens. Okay, the way our laws are structured, when you look at the Constitution, for example, you find that many of the provisions are broad, so to say, and they require the constitutional court or the courts to pronounce themselves, either to give meaning to certain provisions or to clarify, and even where the purpose of judicial review, for example, let's say there is let's take the Electoral Commission of Zambia or any other administrative agency, okay, if they were to act contrary to what the Constitution says or not in the best interest of the public, strategic litigation would come in to ensure that institutions are acting within the bounds of the law and for the benefit of the public. Okay, so strategic interest litigation would only achieve its good mandate. Okay, if all the institutions or bodies involved, okay, are acting together and are looking to achieve a benefit for the public. For example, the legislature and the executive, okay, they should work together, including the public and other stakeholders like CSOs should work together. If a judgment is passed, okay, we need all bodies or stakeholders to come together. The public should be interested and be involved in ensuring that if a decision is passed, okay, there is sustained pressure or a call for the executive to ensure that if it is an issue of, let's say, socio-economic rights, the government or the executive, so to say, ensure, okay, say, a progressive realization of what the constitutional court would say. For example, in a case of people should be entitled to socio-economic rights, for example. So it calls for all parties, the stakeholders involved, to respect the institution of the court and to work together to realize that whatever is being done by all these parties involved, especially the three arms of government, is for the benefit of the people.
Okay. Thank you very much for your time for this very interesting and educative discussion. Thank you for joining us on this episode. And we look forward to seeing what Chapter 1 Foundation will be doing in the advocacy and strategic litigation space.
Yeah, I can tell you it's a busy time of the year. It's a busy time of the year. And talking about strategic litigation, there is need for partnerships even for SAIPAR. Because the research, strategic litigation, like I said, it's not about winning, but if you are to look for good, positive change, there are so many things that go into uh, success. Good research is very key, for example. Okay, so we need uh, good research, partnership with bodies or entities like SAIPA. Okay, we need for the arms of government to work together. Okay, and just recognizing that CSOs are not there to fight with government, but want to help where necessary.
Mm.
Yeah. So it's a busy time of the year, and I can tell you, people say lawyers love fighting, love to go to court, but in most cases, you find that, especially chapter one, would only go to court after the parties involved have been engaged, and there is no positive response, if you like. Otherwise, the goal is to ensure that whatever is being done on the part of government benefits the people, and whatever is done within the bounds of the law and not outside what the law provides.
Okay. I mean, we're looking forward to those partnerships.
Indeed. I look forward to the next episodes.
Oh, yeah.
Yeah.
Thank you very much, Henry. And thank you to our listeners for joining us. Please stay in touch with us by following us on our socials and subscribing to our YouTube channel. And see you in the next one.